Afternoon, landlords. It is great to be back. All right. So, for those of you who missed last week, I also wasn't here. So I'm happy to be back in the month of May. And today we're talking all about that partial payment and what to do if your tenant is not submitting a full payment to you. We want to address, what your options are, what my suggestions would be in a situation like this. I also have your questions. A number of you have submitted questions to me through our Facebook group and otherwise. And so I've got a set of those questions here, which I will address. But first, I want to get into today's main topic. However, if you've got questions for me, hello, James, good to see you again. If you've got questions for me, just like James here, go ahead and add that to the chat, and I will communicate with you directly. If you've got a question for me, I will answer it. So let's dive right in. So, many of you have provisions in your lease that absolutely prohibit partial payment, and there's a reason that you do that. You want to have consistency with your payments, and you want to make sure that your clients or your tenants know that your expectation is full payment upfront on or before the first day of the month. But if you do this long enough or you have enough doors, you're going to find that some people are going to pay late. And so the question for you is, how do you respond to these people who pay a late payment, or more specifically in this case, a partial payment? Now, I would suggest first and foremost to check your lease to make sure your lease has a firm due date for the rent. And just because, and this is something that comes up a lot, just because your lease happens to mention that late fees do not apply until a different date, that doesn't mean that rent isn't late at that time. Understand what your lease says about when rent is due and when rent is deemed late. Because again, just because late fees can be assessed at a later time doesn't necessarily mean that the payment is timely. But also find out what your lease specifically says about partial payments. Is yours one of those leases that absolutely prohibits partial payments? If so, you got to come up with a plan on how you're going to deal with that. Now, some landlords will sometimes ask me, Ernie, I got a partial payment. Should I return that payment to the tenant and then proceed with an eviction? Well, my recommendation tends to be you're better off keeping the money that you have. Now, you may live in a jurisdiction where a rule may be in place that says that you cannot evict if less than 1 month of rent is owed. In the state of Texas, this is true of like a mobile home park for a lot rental. In that situation, a landlord simply cannot evict because a partial payment was made. An entire month or more of lot rent in those situations would have to be owed before a landlord could proceed with an eviction. There are other rules that are different than multifamily or single family homes. So lot rentals are a little bit different. But if we're talking about regular 1 to 4 homes or a regular multifamily in the state of Texas, in Texas, you can proceed with an eviction even for a partial payment, even if it's less than a full month. Check your jurisdiction and make sure that your jurisdiction allows the same. But typically, what I tell landlords is, look, if you've got some of it, that's a positive for you. That's less loss that you're experiencing. But if you send it back, now you just increased your loss, and ultimately an eviction might be down the way because the following month is likely going to either be paid late or also be partial. So what do I recommend? Well, you always want to issue a notice of default. So the fact that they're paying something late, or the fact that they're paying it to you only in a partial amount, means that they are in violation of your lease. And so I don't like hearing when landlords tell me, Ernie, every single month I have to deal with this guy who's paying a partial payment and simply won't pay the full amount. And so my recommendation is always issue a notice, issue a notice, issue a notice. Every time there's an infraction, even if it's not a notice to vacate, issue a notice of default. Because once these pile up, and I preach a 3 strikes and you're out rule, once these pile up, it's going to be easier for a court to say, well, I get you got partial rent payment, but man, you've been dealing with this for a number of months and you have diligently issued written notices. He's had plenty of warning. It's time for him to go because he is in violation of the law. And in this jurisdiction, even for less than a full month of rent, we can evict. And so lay the foundation for a valid basis for you to evict and strengthen it if they are making partial payments with notices. Now, another thing that landlords sometimes, for whatever reason, refuse to do, which I always tell them is a bad idea, you got to assess late fees every single time. I know in leases that I review here in the state of Texas, it doesn't matter that some of the rent was paid. You have to pay the full amount of rent owed at the time, or else if you pass a certain date, you will owe late fees. It's not a matter of owing the full amount, it's a matter of owing any amount. And so, yeah, if they make a partial payment, but they don't make a full payment by the deadline when late fees can accrue, issue notice and mention now additional late fees are owed. It's important that you collect those late fees. And we do a ton of work. We do a ton of content on this channel about late fees and how landlords do themselves a huge disservice by not charging those late fees to their tenants. But they also do themselves a huge disservice by not understanding how late fees work. If you've got certain caps, respect those caps. If you go beyond those caps, understand that you open the door to certain liability from potential lawsuits that could come from your tenants because you've violated probably the law in your jurisdiction by collecting improper fees beyond what's allowed in your jurisdiction. So I know in Texas, we have a 10% and a 12% rule based on the kind of housing. Multifamily, you're limited at 10%. Single family homes, you're capped at 12%. If you go beyond those percentages, there are stiff penalties in the property code here in Texas, and you could be assessed with those penalties and be made to pay the attorney fees and court costs and interest on a judgment because you don't know how late fees work. Learn how they work and then enforce them. Make sure that you are doing that, because otherwise you're going to be frustrated by a tenant who fails to pay on time or fails to pay in full. So always issue notice, always assess late fees. And this is just fundamental bookkeeping. Always apply funds and fees chronologically on your rent ledger. So your ledger should reflect anytime funds go in and anytime funds are owed. And so if your ledger doesn't reflect that because you're not keeping good track, for example, that on the first day of the month, X amount is owed for rent. By, let's say, the fourth day of the month, an additional sum of Y is owed now in late fees. And then that progresses through the month if the payment is not received by that time. And so if a payment is received, say, on the 10th day of the month, it should clear out everything. But if it doesn't, it cleared out the oldest debt first. But understand that if you have an application of funds clause, you can clear out those late fees first. And definitely if you had amounts from a previous month, you clear those out first. And so understand how to chronologically apply funds to the oldest debt first, but also to prioritize the funds to clear out even non-rent obligations first particularly if your lease allows you to do that. If your lease doesn't allow you to do that, you may want to upgrade your lease. Now, I don't know, what things are said in every jurisdiction, but I know for sure in the state of Texas and in many other states, you're allowed to have an application of funds clause in your lease, which allows you to prioritize where the funds go, and you can make application of those funds to rent absolutely last. Clear out all the other debts first, which are owed at that time, and then apply whatever balance is owed now to the rent. So by issuing notice, by assessing late fees, and by keeping your record keeping accurate, applying good ledger practice to your management, you're going to discourage your tenants from paying whatever they want, whenever they want to pay it. And instead, you're going to strongly and strictly enforce the terms of your lease and collect the absolute maximum from your tenant every single time, or at the very least, collect all the rent that's owed on time every time. Again, your goal isn't to punish your tenant with late fees, but the goal is to enforce those late fees in a way to incentivize the tenant to make rent payments on time. And now the last piece of advice that I'm going to give you is actually what should have been the first piece of advice, because it's one of the oldest things I say that I've said for a long time. You have to have your talk with your tenant before rent is ever owed. Before you ever hand over those keys, explain these steps to your tenant. Let them know that you will issue notices of default. Let them know that you will charge them late fees every single time to the maximum, and let them know how your application of funds clause works, so that if you owe money from a prior month or you owe fees, those get paid first and then the rest to rent, so that if rent remains unpaid, they risk eviction. If you explain these things before the lease ever begins, I promise you're going to have fewer bumps in the road. But when those bumps do occur, they're going to know you were serious because you said so initially. And by following through, you're likely to have a stronger landlord-tenant relationship, and you're likely to experience less frustration. And you may even bring what is a mediocre tenant up to top tier tenant status, because now they know what a top tier tenant is supposed to do. If that's happening for you, then you're making money and your landlording is going quite well. But you gotta know how to get there, and you gotta be consistent with your enforcement. So, and I'm sure that will be the case. That's why you're here. That's why you're learning, and that's why you're asking questions. Here we have Alexander Valentin. Hello, Mr. Garcia. Thank you for your live stream. You are very welcome. I'm happy to be back. James goes on to say, is it legal to rent to people who are undocumented? Nope, it is absolutely not illegal to rent. In fact, it is illegal to discriminate against someone due to their immigration status. And while I'm not an immigration attorney, I do know that the fact that someone is from another country, again, that can't come into play in the calculus. If they're applying and they can otherwise demonstrate credit worthiness, and I'll tell you, for some undocumented people, demonstrating credit worthiness is a huge challenge. That's a different topic, though. If they cannot demonstrate their credit worthiness, again, I don't know that I would recommend, in fact, I don't recommend you choosing them as your best possible candidate. But you can discriminate against poor credit, but you can't discriminate against their status and their documentation, where they are on that in terms of their immigration status. Again, I don't know a lot about the immigration process. All I know is that the Fair Housing Act prohibits discrimination on that basis. But again, creditworthiness is a big one, and that one is, I think, important and would not amount to unlawful discrimination. So, James, you are welcome. Let's go ahead and get to the questions. Again, if you come up with a question, just like James did, pop it in the chat, and I'm happy to answer. But for now, I'm going to start with Ardell Breed's question, who asked, prospective tenant credit check, background check, and criminal check. Where do I start? That's a great question. We get a lot of that. So there's a couple of things that I recommend. I do not endorse any one platform or any particular website, but there are tons of them out there. But before you jump on a bandwagon and before you go and say, this is the one I'm going to go with, I would encourage you to go and seek out someone who's done this before. Somebody who's already doing this is going to have some experience with good companies that do good work and bad companies that do bad work. My strongest recommendation is you join a group. If you're in Texas, I strongly recommend, of course, Texas Landlords. That's my Facebook group. We have well over 8,000 landlords there constantly asking and answering these exact kinds of questions. So Ardell, I'm pretty sure this came from that group. I would post that question for the group, and I guarantee you a ton of people are going to respond to it, what they use, what they've used in the past, what's worked and what doesn't work. But definitely you want to find a company that'll do a thorough background check of a person's employment, of their rental history, of their criminal history, and of their credit. You definitely want to check out those four. You want to know if this person's ever been evicted. You want to know if they've ever been convicted of a violent crime or some sex offense. And you're going to want to know that they have a long-standing work history. And you're going to want to know, just how strong their credit score happens to be. But knowing this stuff is only part of your screening. You're also going to want to go and check this stuff, confirm that this report is accurate. And sometimes you're going to find that a person shows up with a shining report, but the identity that they use is somebody else's. And so it's up to you to confirm that they are who they say they are. Don't just take somebody's word for it. Make sure you've seen a physical state issued ID to match a face with a name, because if you're just doing everything online, it's very easy for someone to slip right through the cracks. Someone who's completely different than the ID that they showed you, or perhaps manufactured if you just saw it over email. I would wait and see a physical ID before I give a final okay to someone. So again, get to a group, find somebody who has done it 1,000 times before, or 100 times before, or 10 times before. If this is your first go, find somebody, get their advice, hear their opinion out. There's a lot of people out there with really great personal experience. All right, so TNC Contractor Services says, hello, Mr. Garcia. Thank you for the information. How can we deal with late renters when they have a delicate matter, such as the death of a family member or sudden unemployment? Well, those are two different kinds of questions. If it's sudden unemployment, let me tell you, that's something you have to take seriously. And again, I'm all for being sympathetic. I'm all for being helpful. I'm all for being kind. But if someone is suddenly unemployed and they are the main breadwinner, it's time for that alarm to start blaring. That person can no longer afford to live there. And it's unfortunate that they can no longer afford to live there. But if they can't pay the rent, they can't simply rely on your kindness until they are back on their feet. It may be necessary for them to downgrade to a different option, or perhaps get the assistance of friends and family in the meantime. But again, as part of a business operation, this is not your task to take on. As far as the death of a family member, I talk about this sometimes, that in everybody's life, certain things are going to pop up. And if it turns out that grandma died or somebody else died, and somebody's got to, fly out and spend a lot of money on this particular tragedy, always you're going to want to talk to your tenants. Always you're going to want to know what's going on. And if it turns out this is a one-off thing, it's possible you can kind of, look the other way and make arrangements, or, allow a little bit of delay because you trust them to get back on their feet. The problem is you have to understand that the eviction process takes time. And so let's say somebody tells you, grandma died, we're flying out to Timbuktu, we're going to be gone for about 5 days. If I don't work, I don't get paid. But once I get back, I'm going to work my tail off and I will get you paid. In response to that, I wouldn't change my policy. I wouldn't suggest that you change yours. You're going to issue that notice and you're going to tell them, look, I'm going to get this process started. If it turns out, like you say, and I'm right there with you, I'm rooting for you for it to turn out just like you say. If it turns out just like you say, I'll just withdraw everything. But I'm going to get this in motion in the event that things are actually worse. And maybe you don't share this with your tenant, but just in case things are actually worse than you can currently see or you are presently allowing yourself to believe, in case they're worse, I want to be ready because I'm not going to shoulder this unfortunate event in your life, but I am going to be sympathetic. And if in fact you do get back on your feet quickly, hey, we can just reset everything, no big deal. I'll withdraw all things from the court and you'll never have an eviction on your record. But if it turns out, because again, this is a 30 to 45 day process, that 30 or 45 days later, there's still no change. Somehow they're still in Timbuktu. You gotta move forward with that eviction. It's possible that the tragedy was not an authentic tragedy, or it's possible that the tragedy was so intense that, again, just like with job loss, they're unable to afford the rental. And again, that's not an obligation of the landlord. The obligation is only ever on the tenant to make sure that payment is made on time and in full. So there's that. Alexander Valentin got some more questions here. I have a question. When a tenant only pays part of their rent, I'd really appreciate your legal advice on the following. One, if we accept partial rent payment, does that mean we give up the right to evict the tenant for not paying the full amount? It doesn't, but I'm going to question when you gave that notice to vacate, because there's a couple of situations where I think it works really well and some where it works really poorly. So let's say, for example, we're on day 7 of a given month and a tenant has paid, let's say, half of the rent. And we issue our notice to vacate and say, thanks, but I'm going to go ahead and proceed with the eviction because rent has not been paid in full. And then 10 days later, they pay a quarter of the rent. So now they're up to 75% of the rent. So they're nearly there, but not fully there. What do? Can you continue to proceed with the eviction? Yes and no. So technically they're still in default, but if you accept that additional payment, you take it with a certain implication. See, the first time they paid it and you issued your notice afterward. Now you've issued the notice and they've submitted a payment, and I have no idea what their expectations are, but if their expectation was, hey, I paid this, you should have withdrawn this, or in the conversation we had, you implied that that would be the case. You don't want that implication, you don't want that assumption, and you don't want any speculation. You want to be crystal clear every single time you proceed to the court what your intentions are. In that case, I would strongly suggest that you issue a new notice saying, I've received the first partial payment, which was 50%. I received the second partial payment, which is 25%. However, you continue to owe the balance and late fees, right, potentially, depending on how you applied the first 2 payments. In any case, you still owe a significant amount of rent, and therefore, I'm going to reissue a notice demanding that you vacate within 3 days or whatever your jurisdiction requires, so that, yes, you can continue to proceed, but I would clear up what is meant in your notice to vacate and that you acknowledge that you received additional funds. Because if you don't do that, the court could turn you around and say, no, you took money after your notice. I don't like that. That doesn't pass the smell test for me. And so I'm dismissing your claim. And again, if a significant amount of time has passed since then, and now they've stopped paying rent, that's going to put you in a bad situation because now you have to start the whole process over anyway. So if you accept rent after the fact, I would say issue a new notice. And if it gets to the point where they're just kind of dragging this out and now a new month is on the horizon, my suggestion would be stop accepting rent. So unless it's the full thing, I don't ever recommend that you accept once notice has been given. Once you've given notice, stick to your guns and push forward to the eviction unless they pay everything and your court costs and maybe even your attorney's fees. Because you have to let your tenant know that you're serious about the eviction. Once it gets to that point, it's kind of the point of no return. All right, can we still give the tenant a notice to vacate after accepting partial? Yes, in fact, again, like I mentioned, if they paid partial, you gave them a notice, they paid another partial, you accepted it, I would issue that new notice. Should our lease include wording that protects us from accidentally charging the terms by accepting partial rent? No, I don't think your lease is necessarily the best tool here. It's your practice, and where you draw your line in the sand, make sure it's consistent with that tenant and make sure it's consistent with all of your other tenants. You can add these, you can mention these things in your lease. Just make sure that you're applying it across the board to everyone equally. What's the best way to record or acknowledge a partial payment to protect ourselves legally? Again, if you're going to record it in your ledger and apply it in accordance with old debt first, non-rent obligations next, and then to rent. If you do it in that order, you're always going to be in the best position. Make sure your lease has an application of funds clause or something like it. Are we required to give the tenant a receipt or written notice showing how much is still owed? It depends. So if you are in Texas and you accept payments in cash, you are definitely required to issue a receipt and to maintain a receipt book for all cash payments you received. If you're accepting payments in other ways, no, in Texas anyway, it's not a requirement to issue a receipt showing a balance owed. You might have a tenant management system with a portal that does show that. That's extremely helpful. And so not required, but it is something that I would recommend that you have some kind of software that automatically updates the tenant as to what is currently owed. Should we send a written request for the remaining balance after getting a partial payment? Yes, always, but more than that, a notice of default. So just asking for the money is not enough. You should indicate to them why they are in violation of the lease, what section of the lease has been violated, and that future violation could result in eviction. So just asking for the remainder of the payment in writing is not enough. You're going to want to issue a notice of default so that it's clear that the tenant continues to owe money, but that each successive violation brings them closer and closer to a potential eviction. How does accepting a partial rent affect our ability to start the eviction process for unpaid rent? Again, if you issue a notice and then accept money afterward, it could jeopardize your eviction. It could create a fact issue that the court finds unsavory and then dismisses your case. Do we need to wait a certain amount of time before we can begin eviction after taking a partial payment? I say yes. You have to issue a new notice to vacate, wait out the 3 days or whatever the notice required in your jurisdiction is, wait out that time. Again, reissued notice, new time frame has elapsed, then you can go file. Is there a risk that a judge might think accepting partial rent means we've agreed to new terms or given the tenant extra time? Yes, that's exactly what we've been talking about. That implication exists there, and because it exists, it's important for you to plan for it and avoid any misconception by issuing new written notice. Would it be a good idea to have a policy that says we don't accept partial rent unless the tenant also agrees to a written payment plan? No, I don't think it's a good idea at all because the payment plan is already in the lease. Pay everything on or before the first day of each month. I wouldn't go and create a mechanism where they can, suggest a new payment plan and now you're kind of bound by that term. No, they already owe it on or before the first day of each month. That is sufficient, and that's really all you need. I wouldn't complicate the payment terms any more than that. Should our lease or rent collection policy explain how partial rent payments are handled? Um, no, I wouldn't create some system. What I would say is if you fail to pay 100% of the rent on or before the first, you are subject to, that is a material default, and you would be subject to eviction. That's all your lease should say, that unless the rent is paid in full on time, that's a violation of the lease. That's a material default. That's a material breach. That's a violation that could subject them to eviction. And finally, can we still charge late fees or penalties on the amount the tenant didn't pay, even if we accept partial payment? Find out what your lease says specifically. In Texas, if you haven't paid the full amount of rent, yes, you can charge up to the maximum amount of late fees so long as some amount of rent remains unpaid. And that's it. So we're going to go on to our next set of questions, but a few questions have popped up here. Brian V says, hello, Mr. G. Many years ago, I sued a tenant for non-payment. He didn't show, I won by default, and he disappeared. How can a landlord collect what is owed if a defendant doesn't show in small claims? Well, the fact that they don't show up to the trial, not as significant. What's more significant is, can you locate them now to enforce the judgment? So in Texas, the procedure is you win your judgment, and then you abstract your judgment. And by getting an abstract of judgment, and I have a number of videos on that topic on my channel, by obtaining an abstract of judgment, you secure what's called a judgment lien. Then, if you know where that tenant currently resides or is employed, where you can physically serve them with notice of a writ of execution, then you can potentially collect on that judgment lien based on the assets then owned by the tenant. If they have non-exempt real estate or non-exempt personal property or accounts that you are aware of, these things are all subject to seizure and could ultimately be used to pay off that judgment amount. So you got to get a final judgment. You have to abstract or record a judgment lien, and then you have to execute that lien. And to do that, you're going to need non-exempt personal or real property. If you look on my channel for a writ of execution, I go in depth on what that means, and we talk a little bit about what it means to have exempt personal property and non-exempt personal or real property. So V Gentry 83, whatever you do, don't accept partial payments in some jurisdictions. If a tenant pays $1, they get to stay in the property, depends on the judge in the state. That is absolutely correct. And so if you are in such a jurisdiction where partial payment means you cannot accept it, but you can reject any payment that is not payment in full, then that's really the strategy you need to employ. But you need to know where your property is located, you need to know what laws it's subject to, and then you need to enforce those rules. What's in your lease, what's in the law, and what's in your practice as a property manager. If accepting a partial payment is going to subject you to restriction when it comes to eviction, absolutely don't do it. But if you can accept a partial payment and still evict, even for a partial amount of rent owed, then again, I'm issuing notice and I am making sure that if I have the right to do so, I push forward. Of course, you want to give your client an opportunity to pay everything that's owed, but you don't want this to go without some notice of default or notice of lease violation having been issued. Even if ultimately they pay all of the late fees, all of the rent, all of the additional fees that are otherwise owed, yes, you naturally want to collect those things, but don't skip the notice. V Gentry 83, just do not accept partial payments and let that be that. Again, understand what your situation calls for and do what's best for you. In Texas, you can accept partial, so I never tell landlords not to, but if you are going to accept a partial, make sure your notices are clear every single time. V Gentry 83 goes on to say, I don't understand why you let tenants tell you how to run your business. you're not allowed to go to the grocery store and make partial payments for food. That's true. But I'll get off my soapbox and let you finish the sermon. Hey, we welcome your opinions. We definitely want you to be heard. And again, what you don't want is for the tenant to take advantage of you and just run right over. You want to know what your law says. You want to know what your lease says, and you want to enforce what's best for you and your business. That never means letting a tenant take advantage of you, but it does mean knowing how to enforce your lease terms and to enforce them consistently for that tenant, for each tenant that you serve. Yeah. Okay, next we're going to Edward O.B. Edward O.B. asks, I am soon to give my tenant a notice of non-renewal of our existing lease. I have a feeling that as soon as I give him the notice, 61 days prior to the end of the lease, he's not going to pay rent the last 2 months. I'm trying to avoid the eviction route as it will cost me almost $2,000 in legal fees. Is there anything short of eviction that I can get where I can get the rent or move him out? If you anticipate he's not going to pay, really eviction is going to be the only thing. Your lease is a written notice that tells him he owes the money. If he's not going to follow that written notice that he signed, what makes you think he's going to, follow some really strongly worded letter? It's not going to do the trick. You're going to have to go with eviction. And so if you send a notice 61 days out and the very next day your rent is due on the first of the 2 months and he doesn't pay the rent, the very next day, issue that notice to vacate. And if you can issue a 3-day notice and then within a week you're filing at the courthouse that eviction, then hopefully you get to court within 45 days, within that 60-day span, and you get him out. What you don't want to do is wait out the 60 days and just pray, hope and pray that he actually leaves. If he's already abusing the system by not paying rent, what makes you think he's going to follow the rules any further and elect, I could live here for free because the guy's letting me do it, or I could move somewhere else, sign a new lease, have to pay a new deposit. No, I'm good right here. I'll just stay here and milk this for all I can. Don't let your tenant put you in that position. As soon as there's breach, particularly for non-payment, issue that notice to vacate, begin the eviction process, and let him, risk getting an eviction on his record. And now he's got to deal with the consequences of that. And so, good tenants don't take that risk. Bad tenants will, and they'll push it and push it and push it to get even more and more and more. Don't let them do that. As soon as they do non-payment, forget about what it costs you. It will cost more to let them just not pay, to let them take advantage, because inevitably they'll push beyond that final limit. So next we have Brandy Anderson, who asks, is there any way to get a tenant out during the appeals process? And that's an excellent question, because a lot of landlords don't know that in Texas, there is actually a procedure to get tenants out even before that second judgment. So let me paint a picture for you. The tenant has gone to trial with you in the justice court, that first round trial, and you won. You won a judgment for back rent and possession, but they filed an appeal. Now in Texas, the most common forms of appeal require that the tenant pay something into the court's registry, whether that's an appeal bond, which is usually about 2, sometimes 3 months of rent, or they file in some alternative method, either through what's called an affidavit of inability to afford costs or through what's called a surety bond. I do tons of videos on methods of appeal and different things that come up with appeal. But each of these situations generally requires some amount of money to be paid into the court registry as rent while the proceeding goes to the next court. Now, when the tenant is required to make payment like this, failure to do so enables you, the landlord, to proceed with the purchase of a writ of possession. But if you don't know how to do this, or you miss your deadline for doing it, because the windows can be quite small, if you don't know how to do it or you miss the deadline, your tenant continues to live there rent-free, and all you're thinking is, well, my only recourse is the judge at the final appeal trial. And that's just not true. There is a procedure under the Texas Rules of Civil Procedure that allows for a court to issue an order ahead of trial on appeal that gets the tenant out because they failed to pay their rent into the court's registry as required. In many cases, they're required to pay rent from the justice court at the initial appeal and each subsequent month while the matter remains on appeal. So sometimes it's 2, sometimes it's 3 full months of rent that are deposited into the registry of the court and are there for the landlord once they win on appeal to recover as part of their eviction judgment. But sometimes, cases fall through the crack and the tenant never pays any amount of rent, even though they were obligated to on multiple points. But if the landlord doesn't know how to enforce that part of the law, they miss out, and the tenant stays for free for an extended period of time, and then ultimately leaves. But the landlord has an even greater loss that could have been mitigated by simply knowing how the rules work. Okay, Brian V jumps back on. In regards to partial payment, laws in my jurisdiction would be those laws posted somewhere in the county website. I'm referring to Lee County, Texas. No, if you are in Lee County, you are subject to the same eviction laws of every other county in the state of Texas. I'm referring to people outside of the state. And so I can't speak for anything beyond the Texas border. And I know that most states have similar schemes for eviction, but they're not the same. And so I'm not going to go and talk about, what goes on in Nevada or in New York or in Florida, but I will talk about what happens in Texas because I'm licensed in Texas and I know what happens in Texas. If you are in a Texas county, you're subject to the Texas rules of civil procedure, and those do not change county to county. The Texas property code is the same throughout the state of Texas. If you have a question about Lee County, send me an email, send me a message, ask your questions here. I'm happy to answer your Texas specific questions for sure. Shamek writes, should I get a signature from a tenant moving out when returning their security deposit minus agreed upon deductions? You can, but it doesn't make your position any stronger. You still have the same 30-day requirement once they surrender possession to notify them of all of your valid deductions. Their signature doesn't make your notice to them any weaker or stronger. And I just don't see it as necessary. What's the most important is, can you prove that each of the deductions that you made from their security deposit was a valid deduction? That's key. That's the one that gets landlords in trouble, because they presume they can deduct for this and they presume they can deduct for that, but they are not certain. I do a procedure with landlords all the time where we talk about the red light items, the yellow light items, and the green light items. Green light means go, and everything on that green list is a go. They punched a hole in the wall. They broke the front door. They set the kitchen on fire. All those damages, that's not normal use. That's not ordinary wear and tear. Charge it, charge it, charge it. If they broke property or broke something on your property through negligence or misuse, 100%, that's on them. The yellow, that's a jump ball. That's a 50-50. That's a maybe they did it, maybe they didn't. I don't know. It's hard to tell whether they were guilty for that. And because of that, you got just as much an opportunity to win it as you do to lose it. So I wouldn't rely heavily on those yellow ones. And the red ones are absolute no's, right? If something breaks through normal use or ordinary wear and tear, or that carpet's 12 years old, that carpet is dead. I don't care how well grandma took care of it for the first 8 years of its life. At 12 years old, there is no value in that carpet. You can't charge them to replace carpet that has zero value. Right? It had zero value, so the cost to replace it is $0. So understand, green, yellow, red, that's how I evaluate these things. Rely on the green, rely sparingly on the yellow, but understand what's red and what can never be charged to your tenant, and you're always going to be on the right side of the law. So I hope that helps. But again, if it's still unclear, seek legal advice from an attorney or somebody who's done this in the landlord business for a long time. James, in Texas, you have 30 days to return the security deposit, provided they have given you a forwarding address. That is true. So the 30-day clock doesn't start until they have surrendered the premises and given you a valid forwarding address. That is 100% true. Alexander goes on, thank you, Mr. Garcia. I truly appreciate you taking the time to answer my questions. You are very welcome. I appreciate you reaching out and getting us stuff to talk about. Sven says, hi, Mr. Garcia. Hi, Sven. Good to see you. All right. So we are now going on to our very last pre-written question. This comes from Amanda Lopez. Here we go. We consider setting up an LLC to shield ourselves from potential liability. For this to work, does the property title have to be in the name of the LLC? Great question. So let's say somebody owns property in their individual name and they're thinking about using an LLC. Well, you can use an LLC in a number of ways. The LLC could be a management company, and all it does is it signs leases, it sets up repairs, it hires contractors, and it collects rent, we'll say. But it doesn't own the property. And so, yes, you can use an LLC that way. And as far as the tenant knows, they get all their information from the LLC. All their communication is with the LLC. And while the contact person from the LLC might actually be the owner, as far as they know, it's just some faceless corporation, and you happen to be an employee of that LLC. But let's say something goes wrong and then there's a lawsuit. Well, the LLC as the property manager might be sued, but you can bet that the owner, and if that's you in your individual capacity, is going to be sued. That's you. So both your company and you will be sued. So it probably makes more sense if you're looking to shield yourself from your business assets to have the LLC both be the owner and the manager of the property, so that, again, the only one who will ever be sued in that situation will be the LLC, because they both own and manage the property. Now, if you're looking to distinguish between multiple rental properties, you may either do one of two things. Either have separate LLCs, one for each property, so that no one property takes out, cascades down to the other properties, because the claim is so high and the value of this property isn't enough, takes out everything else. If it turns out you've got a claim like that and there's an LLC that owns it and manages it, but all the other properties are different LLCs, guess what? That claim is limited to the value of that LLC and what it owns. It has no effect on any of the other business property, and it would have no effect on you individually. So understand how you want to use your LLC, but my recommendation is if you want personal liability, you have to get rid of your personal connection to the property. And so if you're going to have an LLC manage the property, probably should have that same LLC. And I say probably, I say it might be a good idea for you to have that LLC also own the property, so that at the very least, you no longer have personal connection to the business property. Now, complications do come up when you still have a loan in your name. The lien holder may require that you get written permission from them before you transfer your property to an LLC. Make sure you understand what your promissory note says in this kind of situation, and make sure that if you do intend to change from yourself as an individual to the LLC, that you've at least brought that up with your lien holder. And if you can get it, the best thing to do is to get written permission from them before you take that kind of step. So I appreciate all of you who hung on through the end. I'm happy to do these Wednesday afternoon talks and look forward to doing the next one. Next week is the 28th, and our topic is the tenant put up a trampoline. Should I be worried? You might already know my response to that. What do you do when your tenant wants to put up a trampoline or do some other crazy thing? We're talking all about that next time. But until then, landlords, I hope you have a wonderful holiday weekend. Enjoy it. James, you are welcome. Sven, thanks. Yeah. Thanks, Mr. G. See you next week. Thank you. Guys, I appreciate you so much. And as always, happy leasing.